Good morning, everyone. Just give it a couple of minutes for everybody to arrive. Thank you to all for joining us. Alrighty, thanks again to everyone for joining us. I'll just do a couple of housekeeping things while we're waiting for the last attendees to arrive. Today in our session, we are going to be talking about compliance and growth in 2025 for your contingent workforce. So I'd like to welcome today Steve from our employment law team at EPG Group, and Darren, who's from our customer enablement team at Xemplo and also Platinum Workforce Management. And I'm Ryan Averko. I'm our Senior Product Manager for HR at Xemplo. Okay, so today's session, we're going to be covering key legislation changes and how they impact compliance for contingent workforces specifically, compliance challenges in managing a contingent workforce, strategies for compliance and growth in 2025, and then we'll have a short Q&A session at the end of the session. So if you have any questions as we're going through, please pop them into the chat. We'll keep those for the Q&A session at the end. If we have, for whatever reason, too many questions from at the end of the Q&A session, we may take some of those offline and contact you directly afterwards. So please add as many questions as you have throughout the session, and we'll get to as many of them as we can. Okay, so to kick us off, in terms of key legislation changes impacting all businesses and workforces in Australia introduced throughout 2024 and coming up in early 2025, and the compliance challenges these present for contingent workforces specifically, we're going to start with Steve, who's going to kick us off to introduce those legislation changes and tell us all about what's going on with them. Thank you, Steve.
Thanks, Rihanna. It's great to be here with everyone. So as Ray said, I'm Steve Forster. I'm the General Counsel of the EPG Group, and I'm also the Principal of EPG Legal. That's our affiliated migration and employment law practice. Anyone who has paid any attention to the news or is involved in employing people, as we all are, will know that the last sort of 24 months in particular have been an incredibly dynamic time for employers with legislation changes, and particularly, changes that affect those who engage or employ contingent workers. We would have to be here for hours, if not days, to get through all of them. So what I want to do is focus on a couple of specific changes that have either recently occurred or are upcoming, which in my view are particularly important. So those are the recently introduced right to disconnect, the same job, same pay laws, and also the impending criminalisation of underpayments. So with each of those subjects, I'll give you, just a quick summary of the update, talk briefly about the consequences of getting things wrong, and then given the focus of today's session is on contingent workforces, I'll spend some time discussing what are some of the unique challenges related to these updates in that context. Later on in the session, I promise we'll talk some solutions and best practice and approach to ensure that you're on top of these particular updates. So diving in, let me start with the, I suppose, highly publicised right to disconnect. This is a new workplace right, and what it allows is employees to do is refuse to monitor, read, or respond to contact or attempted contact about work-related matters outside their working hours unless their refusal is unreasonable. So just on this new right, one thing very important to say, this is already up and running. It commenced operation on the 26th of August 2024 for most businesses. For small business employers, that is employers with fewer than 15 employees, the right will only commence on the 26th of August next year. But for most of us on this call and for most in the contingent worker space, it's certainly already up and running. What does it mean? Well, The right to disconnect is not a prohibition on employers making contact with employees altogether. Rather, it's a protection for an employee who, when they are contacted or subject to an attempted contact after hours, reasonably decides not to engage with it. And how the protection works is when it happens, an employee cannot have any adverse action taken against them for exercising the right. So, put another way, if a worker exercises their right to disconnect, then they cannot be, dismissed, warned, demoted from their role, or subject to any other sort of negative action, such as being overlooked for a promotion, a pay increase, or career development and the like. It's pretty high stakes because it is adverse action. If an employee suffers it, they are able to bring what's called a general protections claim under the Fair Work Act. And if they're successful, a court can do a lot of things, but the primary remedies are awarding compensation to employees, and there's no cap on the compensation. And courts can also impose penalties of up to around about 20 grand for individuals and pretty close to 100 grand on businesses. So as I said, high stakes and important to get right. Now, I'll come in a moment to talk about some of the unique challenges that the right to disconnect poses for contingent workers, but I do want to just pause for a minute to note, look, it is important that the right to disconnect only protects employees when their refusal to connect is reasonable. So that means we need to focus our attention on what is and what isn't reasonable. Certain matters are considered as a matter of law when making that judgment. And so these are: what was the reason for the contact or attempted contact? How the contact or attempted contact was made and sort of how much disruption that might cause to the employee. What is the nature of the employee's role? And so that's focusing on things like, are they a specialist? Are they a manager? Are they a people leader? Are they client facing and the like? The employee's personal circumstances are relevant. So things like their family and caring responsibilities, and also what they're paid. That's really going to be critical. So is the employee compensated for being around to monitor and respond to conduct out of hours, or to do work out of hours, either by their salary, for example, or some additional payment, be that overtime or a standing by allowance or the like. They're not the only things that can be considered. Effectively, anything can be considered, but they're the critical things that I think will be fixed upon when this question is being assessed. There haven't been any cases yet looking at how this right to disconnect will work, but I don't think it's hard to envision certain circumstances where it will be obviously okay to expect an employee to respond out of hours versus when it will be obviously not okay to expect that. So when it will be fine, for example, is if you have a senior employee or a specialist employee, perhaps who's client facing, who is responding to an emergency, and they're paid a salary that compensates them for everything. I think, in short, that's a case of go for it. There's no issues with doing that. I think with a junior employee or a not so senior employee, someone who's perhaps not as highly paid, and where the matter is not urgent and could feasibly wait until tomorrow, I think it's best to try to avoid out of hours contact if possible. But certainly, and this is the critical thing with the right to disconnect, it's to avoid taking any negative action against them if they actually do refuse. As I say, no absolutely hard and fast rules, and because there is a focus on the individual's unique circumstances like family responsibilities and carer responsibilities, you can never rule out an issue if you do take adverse action because an employer refuses. But there are some pretty clear markers of what will send it one way or the other in the assessment. Now, for those of us who are engaged in the management of contingent workers or advising on contingent workers, there are obviously some unique challenges, I think, related to the right to disconnect. I think these arise for a couple of reasons. Firstly, the right to disconnect isn't just a right to refuse contact from the employer. It's actually a right to refuse any work-related contact. So that would include contact from clients. And in the contingent space, where employees are reporting into client reps and our clients have high expectations, it's necessary to manage contact from not just, you, the employer, but also the client too. I think the second, real challenge arises because just of, the nature of contingent work. Contingent workers often have less stable and predictable hours, for example. That makes it harder to define, what are their working hours versus their non-working hours when the right to disconnect protects them. Obviously, many contingent workers are paid based on deliverables or hours worked rather than a fixed salary. So this might create pressures on them to sort of pick up more work outside traditional working hours and, efforts to meet deadlines at unusual times. I've already mentioned that, issues arise because of contingent workers reporting into third parties who might have high expectations. But the other challenge that presents is that you're just not in the mind of your clients when they're making critical decisions that could affect your contingent workers when it comes to potentially career development and opportunities and rostering and those sorts of things. And then finally, even simple things like, cross-border and time zone issues will arise if, the host or the client is based outside of Australia or vice versa, and the worker is working at different times. There can be a tendency for managers, to expect workers to be responding in their time zone, not the time zone that they work, and that can create some issues. So as I said, I'll return to some solutions for this, but these are the kind of issues that employers of contingent workers or those who engage with contingent workers should be thinking about and taking necessary steps to ensure, are accommodated. So Ray, I'll move on now to briefly mention the same job, same pay laws. This is a really big issue that's squarely directed to contingent worker businesses. I think most of us on this call, understand that the engagement of contingent workers is a really legitimate practice to augment, a direct hire workforce through periods of increased demand or to address skill shortages or where direct hire is just otherwise not feasible. However, there is a view amongst some, and it's particularly so amongst the trade union movement, that contingent workers are engaged to undercut wages of direct hire employees where an enterprise agreement has been negotiated. The federal government, I think, yielded to that latter view in amending the Fair Work Act in 2023 to require the Fair Work Commission to make what are called labour hire arrangement orders, or what's colloquially, the better term that we've all come to use, same job, same pay orders. Now, so I mentioned that these amendments were made last year, but the actual orders themselves can only come into effect, or did only come into effect, on the 1st of November this year. So what is a same job, same pay order? It's an order that requires an employer of a contingent worker to ensure that that worker is paid no less than the full rate of pay that an employee would receive if they were directly employed by a host business under the host business's enterprise agreement. So when you're looking at the full rate of pay, something important about this is it's not just the hourly rate of pay that would apply if they're employed by the host. It's really everything that affects the monetary entitlements of that worker, or all monetary entitlements. So things like incentive-based payments, loadings, monetary allowances, overtime, penalty rates, and the like. One of the questions that's been forwarded to us in advance is, when will a same job, same pay order be made? And I'm happy to address that. Unfortunately, the Fair Work Commission does not have a great deal of discretion here. If there is an entity that supplies employees to perform work for a host company, and those workers would be covered by an enterprise agreement of the host if they were directly employed, the Commission has to make an order that same job, same pay applies, unless one of a few limited exemption applies. So very limited discretion. What are the exemptions? As I said, very limited. You'll be exempt if the host is a small business, so that is a business with fewer than 15 employees. If the workers are engaged to provide a service rather than a labour hire arrangement. You can raise an argument that it's not fair and reasonable in the circumstances to make an order. I think that will be difficult to do, but the kinds of situations when that might arise are, say, for example, if you're only supplying a worker for one day or a few days or very, very sporadically. And then finally, labour hire, same job, same pay orders cannot be made if the workers are being supplied by, a registered training organisation as part of an apprenticeships or other training arrangement. So what happens if a same job, same pay order is made and you get it wrong and you underpay? I really cannot underscore the significance of this enough. Failure to comply with the same job, same pay order will be a breach of the Fair Work Act because it will be an underpayment. And as an underpayment, it can expose companies and individuals to massive fines and commencing 1 January, as I'll come to explain in a bit more detail in a couple of moments, even imprisonment. So look, what are the unique challenges this faces for contingent workers? Well, the starting point is to say that this regulation is squarely aimed at contingent workforces. But there are a couple of, I think, really significant challenges that I see for businesses in attempting to comply. The first is calculating the full rate of pay that the host would pay so that you can actually meet your minimum obligations under the same job, same pay order. As many of you will know, enterprise agreements are often really nuanced and have many different types of entitlements. Some of those entitlements can actually be quite unique. And it's often the case that the entitlements in an enterprise agreement have been negotiated over many rounds of enterprise bargaining, and really only the parties to the agreement have any considerable knowledge of what the terms are and what they mean, because they were the ones who sat around the negotiating table and agreed it. So as an outsider looking in, it can be really hard to interpret an EBA. And unfortunately now, if a same job, same pay order is made, this interpretation can lead to inadvertent underpayments and expose employers to those risks. So having strategies to ensure you're calculating the full rate of pay is really important. I think the next thing that's going to be a challenge for the industry and something to be aware of is the way that the billing models apply and the contractual arrangements apply in the sector. Contingent worker suppliers, might be subject to various, long-term billing arrangements or contract stipulations that labour costs that aren't claimed in the relevant billing cycle can't be claimed later. And if labour supply contracts don't cover all costs, then there is a risk that hidden labour costs can arise later, eat into margins or even totally wipe out margins. So they're the things to be thinking about. We'll talk more about strategies to deal with that shortly. The last thing I will briefly mention, it's certainly not the least of these things, is the impending criminalisation of underpayments federally in Australia. This criminalisation of underpayments regime kicks off on the 1st of January 2025. Underpayments in Australia are commonly called wage theft, and so what we're now living in is a criminalisation of wage theft environment or period. For the purposes of the Fair Work Act, and employers will commit a criminal wage theft offence if they're required to pay an amount to an employee under the Act or an award or an enterprise agreement, and they engage in intentional conduct, so it must be intentional, that results in an employee not getting paid the full amount due to them on or before the required date. What happens if you get it wrong? Well, the starting point is it's now a criminal offence, but also the consequences of that offence have gone up drastically. For companies, a court will now be able to impose fines of 8.25 million or 3 times the amount of the underpayment if it's greater. And for individuals, fines of 1.65 million or 3 times the amount of the underpayment if it's greater. And the real kicker, there is now the capacity to sentence individuals responsible for wage theft to periods of imprisonment of up to 10 years. So there has long been a microscope on employers getting avoiding underpayments and ensuring that they're paying employees correctly. There's been big penalties for business who get it wrong, both reputational and financial. We're now in an era where the stakes are even much greater financially, but also in terms of it having the capacity to impact individuals' liberty. So the obligation to get it right is as critical as ever, or more so, I should say. Just in terms of some unique challenges for contingent workers, there are many, but I think two things to bear in mind for contingent workers. Firstly, it starts with getting the engagement right at the start. Specifically, I'm talking about avoiding misclassifying a worker as a contractor when they are in fact an employee. There's always been a risk that misclassifying a worker as a contractor and not an employee could lead to an underpayment, or fines, and sham contracting claims. However, deliberate misclassification that results in an underpayment now, will result in allegations of criminality, I believe, and therefore potentially more significant consequences. Secondly, there's a challenge because of the nature of contingent work itself. It can be very difficult for the employer, to know precisely when an employee has worked or is not working, and to make and maintain the kinds of records that are needed to defend an underpayment. In my experience, and I've been involved in a lot of underpayment claims as an advisor over the years from my time in private practice, employers, are typically undone by the absence of accurate records, or at least, this undermines, their defences to claims that they've paid employees correctly. This is obviously harder in a contingent worker setting where the employer, might not own the rostering, time recording, or recording of leave and payroll adjustments, systems and processes. Massive challenge, but the law will not excuse an employer for not knowing when an employee was at work because it wasn't in control of those systems. So it's certainly essential for businesses in this era of wage theft, to be really engaged with contingent worker clients to ensure that you are aware when people are working and not working, and have the right systems in place to address concerns of underpayment as they arise. So look, they're the three critical updates that are all happening about now that I wanted to mention. I'll throw it back over to you, Rihanna.
Thank you, Steve. Thank you for that deep dive. So as we mentioned in the introduction, Steve gave us that fantastic view of all of the key legislative changes that introduce compliance challenges, but they aren't the only things that we have to focus on. So now I'm going to ask both Darren and Steve to discuss additional compliance challenges when managing contingent workforces. We touched on a few of them then, actually, but we'll do a bit more of a deep dive in how they can impact contingent workforce employers and what to look out for. So one of the ones you mentioned there, and it's probably broader than the key legislative changes anyway, is with contracts and engagements. So, Steve, can you share your...
Yeah, it's a good point, Ray. I probably should have raised that in the last section. But so employee misclassification as it relates to contractors and employees, remains a critical issue for contingent workers. There actually was a legislative change on the 26th of August this year that impacts it too. So perhaps I could have addressed it in the previous section. But basically, misclassification, as I said, a perennial challenge, is very much back in the spotlight. And it is because of a new definition of employer and employee that was inserted into the Fair Work Act earlier this year. And the definition was enacted in response to a couple of High Court cases, one called personnel contracting, one called JamSec. Some of attendees today may have heard of them. But those cases sort of effectively changed the game for engagers of contractors by saying that if you're making a decision about whether someone's an employer or a contractor, you only need to look at the contract and not what occurs in practice. So that was a really big shift in the law following those cases back in 2022. The change that's happened in 2024 is to reverse those cases and take us back in time to the old days when, in order to determine if a worker is a contractor or an employee, you need to look at the totality of the arrangement and apply a multi-factor test to decide that. That means looking at things like control, degree of integration, use of equipment and tools, remuneration modelling, ability to subcontract and delegate, and the beat really goes on. It's a really long and amorphous test. But yeah, it absolutely means we're back in the days of needing to do assessments to get this right. And we now know, because of things like higher penalties and criminalisation of underpayments, that the risk of getting this wrong is massive. So our listeners today need to make sure that, reviewing contractor agreements, reviewing the contractor workforce to ensure that it now focuses on the totality of the arrangement, and getting advice where you have any concerns. Just finally, before I hand it over and let somebody else speak, something that is important and hasn't been in place in the past is that there's a new opt-out arrangement or regime that's been included in the Fair Work Act for independent contractors. So if an independent contractor is earning above the high income threshold, they can opt out of the Fair Work Act. If you do have, therefore, an independent contractor who might be on the borderline between, that test of, are they an employee, are they an independent contractor, and they're really well paid, an opt-out notice is one way to mitigate the risk of claims related to that.
So yeah, and just to reiterate what you were talking about there, when we get to the next section where we talk about strategies to implement for some of these compliance challenges, we will come back to talk about how you test whether your contracts are fit for purpose and some of the other things you can do for assessment, etc. One of the other compliance challenges that we all spoke about together ahead of this session was onboarding. It's one of the most popular parts of Xemplo for a reason. There's a lot to be done when onboarding new workers to your business, and it does need to be done as efficiently as possible so you can get that individual to whatever assignment it is that they're doing as quickly as possible. So I might actually jump over to Darren now, who's going to share with us some of the sorts of things that in particular have come to prominence recently where we have to consider when onboarding contingent workers, especially in light of the idea that they're going to an assignment with a client.
Yes, thanks, Ray. Thanks for the introduction. So yeah, Darren Berson here from Xemplo and Platinum WFM. So I look after the enablement side of Xemplo and also Platinum WFM, which delivers contingent workforce management solutions to clients like yourselves. So look, from an onboarding perspective, the key thing here is actually having pre-programmed compliance in place. So having good processes and systems in place that allow you to onboard your workers effectively and efficiently. So obviously the key things here that we all need to take into account are things like work rights, safety, work fitness, licensing, credentials, and all other components there that are essential, as Steve's pointed out, to ensure that your contingent workforce is compliant. I think for us over the years, the thing that we've become very accustomed to is the idea of having really good systems and processes in place. So from an onboarding point of view, making sure that your systems and processes are electronic, they're integrated with your ATS or your other CRMs, because the other issue here, like Steve's pointed out, is if you don't comply in the sense of having good data being transferred through your systems, there's ways that things can be missed. So before you know it, your red flags are popping up that your front office hasn't communicated very well to your middle office, and you're missing key components of that onboarding, which is making you non-compliant. So for us, what things that we focus very heavily on is data duplication, re-entry. They're all the worst enemy of contingent workforce management businesses, and they open us up to error and also missing essential onboarding data. I think the other key thing here from a holistic point of view is also making your staff's data management experience a lot more efficient and effective. As Steve said, there's a lot more demand on businesses now to manage their workforces. So it's also important that your own internal staff have the data and the capability to do that. So that also comes back to their retention and not feeling like they're stressed that they're trying to manage lots of balls in the air. I think one other key thing, that Steve's pointed out is just knowing that your onboarding is collected, stored, and referenced in a central location. So we want to find a conveyor belt where that data all comes together in one central location. It's accessible, it's secure, it's electronic, and it's scalable for growth. that's an essential component for growth in 2025. Other things that we look at are things like automations to identify missing data, incomplete data, or alert users to steps that have not been completed. So, as Steve pointed out, missing something is not necessarily an excuse to Fair Work or the legal side of things. So you want to make sure that you've got great mechanisms in place to remind you, alert you, and help you manage those workforces as they move through the system. Other things we look at are things like electronic checklists, schedules, standard operating procedures, and mobile apps to both improve the onboarding process, but also enhance that data collection process. I think, look, they're key elements I just wanted to touch on today, Ray. So I'll hand back to you and Steve.
Well, actually, just to ask a couple of questions about a few things you said then as well, Darren, because we're kind of crossing from, and it's one of the things that we stress a lot when we're talking about Xemplo as well. It's not just about compliance during the onboarding phase. You've then got an active worker that you need to manage throughout their entire life cycle with your business. And there is the element for contingent workforces of there's a shared responsibility between an employer and a client to understand exactly what somebody is doing so that you can then make sure that you are meeting your compliance obligations. So can you maybe share some of the compliance challenges that you come across when it comes to managing ongoing worker activity and assignments, especially in light of the fact that you'll be working with a client and there is information that you need to be getting from both a contingent worker and also the client?
Yeah, look, obviously the assignment is the contract you have between your client and the contingent workforce or the worker to work in the workplace. So it's critical that you get all those components correct, both in terms of the pay that they're being paid, their individual credentials. So from our perspective, I suppose the key thing with Xemplo is that we can share that data across both the internal middle office, the worker, and also the client through things like their services agreements, their contracts, and also the assignment that's created to manage that process. So that whole assignment process is critical, passing through, the data that's collected from timesheets. So like Steve said, we know when the worker's working, how they're working, what are some of the aspects that are being involved in recording their attendance at work, but also, making sure that aligns to both the actual contract you have with your client, but also the contract you have with your worker. So, a product like Xemplo is critical in bringing all that data together, both for current auditing processes, but also for future auditing purposes.
Yeah, and you've got the visibility across everybody involved in the process, so the client
Correct.
and the employer and the worker themselves. Okay, thank you so much. So with that, we're going to move into the next part of our discussion, which is time to act. So understanding what's possible and, all the different potential levers or compliance challenges as well as potential opportunities you have to grow. You now need to be able to effectively take advantage of those opportunities as well as meet the compliance requirements. So adapting or pivoting in a way that gets you the benefits of any change in an optimal way is what we're going to discuss next. So Steve or Darren, and we won't start with Steve because we've already spoke about a couple of these. Can you share what a business should be doing next if they have questions, for example, about whether contracts are fit for purpose, how we do an assessment of different forms of engagement, etc.?
Yeah, certainly. So I might just make some comments on some actionable strategies to address each of the recent legislative changes that I've mentioned, and then circle back to, more broadly ensuring that you're getting engagements right, and that, the documentation properly reflects your engagements. Let me start with the right to disconnect. Several things need to happen to ensure that it's being complied with, and this is the case really for all employers. I think the starting point is an identification of roles where contact outside of working hours is likely or unlikely is important. And then once that's done, discussing with and educating managers on the right itself and how it applies. There can be, useful guidance given to managers around things like what's the best way to contact people out of hours, what circumstances you might do it, what levels of employee that you should feel more comfortable contacting out of hours and the like. And we've prepared here at Xemplo, some template documentation that is capable of being distributed to managers to, explain that right and get them across it. Really important that contracts of employment are updated to address the right to disconnect. There are a lot of contracts that, provide that an employee is paid a salary and that the salary compensates them for all work. But it's now actually critical for a contract of employment to say, if this is the intent, that the salary also compensates the employee for being, ready and willing to respond to conduct out of hours. So that's really critical too, to ensure your employment contracts are updated to deal with that. And again, at Xemplo, I think it was on the 26th of August, we updated all of the contracts in the system for our clients so that was ready and there for them. Finally, all employers should consider implementing a policy that sets out how the right to disconnect operates within that business. And again, so far as possible, that should be delivered to all employees. And we've got a draft available in Xemplo for download if anyone's interested. Just stepping back though and looking at the right to disconnect more broadly in the context of contingent work, as an advisor, I think there's just a little bit more to it and a few things to be aware of. One is, I think it's important in customer terms and conditions that customers, acknowledge and themselves understand the right and give you a commitment to comply with it, because after all, they, will have representatives contacting your workers potentially at all hours. So some education of the customer on it is important. I think regular discussions and reviews with customers to ensure that the right is being managed well is important. And something that's interesting and a unique challenge that we need to deal with is, if there is now an issue and say a customer approaches a contingent employer and says, we want to end an engagement with worker X because of poor performance, it probably is necessary to test with that client now whether the poor performance is linked in any way to the exercise of the workplace right, not being available. Because if you don't test it, there is, I think, a risk that you're walking into a claim that you're just acting on the advice of the customer in circumstances where they're acting because they've got concerns about an employee trying to disconnect. So that's really important. And I think it really reinforces, I guess, just the broader importance of engaging with customers during the employment to ensure that the performance is being objectively and lawfully assessed and documented. And whatever you can do to kind of automate those processes through multi-party performance management tools and reviews and the like is really, really important. With same job, same pay for contingent worker employers, I think whenever you commence supplying staff to a new client, it's going to be important to understand what their enterprise agreements are and kind of sit down with them and understand how they actually apply, because these, after all, could shortly become the instruments that set your minimum terms and conditions. I think regularly reviewing and doing pay audits and the like is important to ensure then that you're meeting your same job, same pay obligations. And just on the T's and C's, it's important to ensure that your commercial terms with clients include protection to reimburse you for any obligations that arise under a same job, same pay order, because you don't want to lose that margin. On criminal underpayments, there's a lot to this, but it really is moving forward more important than ever to understand what entitlements you must pay to each staff member and why. You must have appropriate systems and processes in place to sort of get the timely payment and accurate calculations for those payments out, whether it be weekly, fortnightly or monthly. Record keeping is so important. As I mentioned earlier, this is the thing that undermines employers or cruels their ability to rely on defences to underpayments. So get that right. Make and maintain the records that you need to. Have good processes and procedures in place for employees to query entitlements and to seek clarification if required. Keep an eye out on information that's coming out from advisors like us or regulators on changes to legislation that might impact your pay and obligations, and then do regular compliance audits. And then I think that the last thing, consider outsourcing your payroll to someone who does this day in and day out, because that's an important measure, I suppose, to show that you've ticked off your due diligence to try to ensure you get this right. What it will certainly do is increase your capacity to say that any underpayment that you did make was inadvertent, if that does happen, and you were engaged and seriously dealing with the issue to try to get it right. In terms of more broadly, ensuring that employees and contractors are engaged in the correct categories and that their contracts are correct and maintained at all times. I'd simply reiterate the point that Darren made, that trying to sort of automate that compliance is absolutely critical. Try to, if you can, partner up with businesses like, Xemplo, that actually do more than simply provide a template, but are actually sitting behind a system and supplying you with not just updates, but also up-to-date contracts and assets that address changes as and when they occur. Because something I noticed a lot in my career as an advisor prior to joining this group is that a lot of businesses will get contracts reviewed periodically. They might be reviewed once a year, once every 2 years. And at the time they are reviewed, they are absolutely 100% spot on correct and they work. But the reality is, if there's been 25 to 30 employment law changes, over 12 to 24 months, they very quickly can become out of date. And rather than having to kind of continually go back and pay for updates and get those updates done to ensure compliance, a much better approach is to sort of outsource the maintenance of that compliance to someone that's regularly updating those things. I think that's absolutely critical to do.
So on that note, actually, I was going to mention earlier and I did have a question in the chat, thank you to whoever asked, about the right to disconnect policy, which I will share with everybody on the webinar after the session. And it's also available from within the Xemplo app, actually. So if you go to company settings, documents in the resource center, which is a little question mark in the bottom right hand corner, you're able to download any of our policy documents. So I'll send those instructions to everybody after the session. As well as that, even if you aren't using the Xemplo contract builder, you are able to actually create a contract template in the library using the Xemplo contract builder, and then you would be able to see our default right to disconnect clause that we include in all of our contract templates, so then you could then choose to adopt that in your own contract templates if you're still using your own contract templates. Probably another thing I would add as well is we are in the middle of launching a contingent workforce staffing sector specific set of contracts for the Xemplo contract builder, which will be available to all customers in Q1 of 2025. So if you are using maybe legacy contracts that you created prior to using Xemplo, and you maybe want to move to the model that Steve was talking about, outsourcing the management of essentially the compliance of contracts to us, you would be able to use the Xemplo contract builder to get staffing industry specific contracts that we keep updated as well. So thank you, Steve. Now I'm going to, and I apologise for this, Darren, I feel like I'm probably throwing you under the bus a bit. We've got an unrehearsed question. So a couple of times here we've spoken about the importance of adopting technology, particularly in relation to record keeping, because yes, as Steve pointed out, it is one of the things that you will have to rely upon heavily if you ever get into a situation of having to prove that you comply with a specific requirement. One of the things that I've seen in my career in HR technology, and I know you would have seen tons, is the migration from like a manual paper-based process to using technology for something, and some of the pitfalls of that. So I was wondering if you could share some strategies for successful technology migration.
Yeah, big question, Ray. Look, I think Platinum was built in 2013 off the back of the fact that a lot of recruiters at the time were collecting things, data in manila folders and storing them in big cabinets. And, that's an incredibly manual process. So for us at the time, we were building systems that automated that process. The main thing we wanted to focus on was being able to electronically collect data. So I think the key thing in that migration process is trying to turn that paper forms or any of your paper-based systems into electronic systems. So the beautiful thing about Xemplo that we love, and the reason why we moved to Xemplo with Platinum, was the fact that we have a mobile app, which means that workers can import that data electronically. They can even take a photo of their timesheet and submit their timesheet. So just trying to eliminate that need for paper-based documentation is critical. Expanding on what Steve said, having an audit trail of a log of information in the system. So the beautiful thing about the payroll system and Xemplo is that all the actions that we undertake are being tracked and logged in the system. So whether it's communicating with a particular worker about a particular event, anything about a timesheet or an invoice that's been sent to a client, even to the level of collecting documents and contracts, is all recorded in the system in a central location. So I think from an auditing point of view, in terms of migrating from a manual-based to an electronic-based process, this system allows you to do that. So look, it's not easy going from a pure manual process to an electronic process. You need to start somewhere. We started somewhere in the sense that we knew that from our perspective, the onboarding and the contracts process was the most convoluted. So even starting there as an organisation in terms of making that your first step to make sure that your manual process is electronic is a great place to start, because the data then can flow through your system from start to finish electronically. I often talk about a conveyor belt. You want to make sure the data you have coming on your system from your ATS or your CRM flows through your entire system from start to finish, because if that data has to be taken off the conveyor belt, if it has to be re-entered, duplicated or whatnot, there's just another chance of having an error, non-compliance, or an issue that might come up in the future that you hadn't foreseen because that data is being tampered with along the process. So hopefully that answers your question, right?
No, it does. Touches on all the points I would raise myself. So thank you, Darren. So there's one last thing I want to jump into, just because we have also referred to this a few times throughout the session today. Before we go to Q&A, we have had a few questions. We'll try and get to all of them. Future-proofing contingent workforce strategies. As Steve mentioned, it's been a busy time in employment law. There's been a fair bit of change. 2023, 24, slowing down a little bit in 2025 potentially, but obviously there's an election on the horizon, so who knows what might come up. But in terms of future-proofing your contingent workforce strategies and understanding compliance that's coming up on the horizon, are there any strategies you recommend for that as well? Specific kinds of industry relationships, particular methods for engaging advisors and experts when you need them?
Look, I think all the above, right? Having good links to industry associations like APSCO, the RCSA, and there are many others, are all important in terms of getting the best advice. I think also, we just talked about automation. So from our perspective, we look at people, systems, and processes. Having great advisors, whether they be advisors like Steve or industry advisors, is fantastic for your business to make sure you are ticking the right boxes. Having great processes, so planning those processes out and systemizing them, from the onboarding process all the way through to timesheets, invoices, payroll, governance, and reporting are all critical. I think also automations in your process, so having automation checks, whether they be compliance checks and balances, checklists, gates that information has to go through, so they'll be red flagged if they're not correct or they haven't been completed. All of these things, and I think also moving it into a mobile world, are all aspects of future-proofing your contingent workforce management processes.
Fantastic. One last question for Steve in the same vein. We did talk a lot about the idea of showing the appropriate level of contrition and doing the right amount of record keeping. It can be your best defence in the case of Fair Work action in a lot of cases. Can you tell us a little bit about what kinds of record keeping above and beyond what you get from a payroll system you would need to think about doing, or processes that you could put in place? Self-audit, for example.
Yeah, look, I think a good payroll system will help you make the records that are required to meet your requirements under the Fair Work Act. So that's payslip records, and then the pay and hours records that are needed to demonstrate that an employee has been paid correctly. But the critical thing then is, if those records are not correct, then and it's your obligation as an employer to prove that they are correct, then it won't go too far for you. So you do need to be relying on more than just the systems that are in place, or relying on more than just the presence of those systems to demonstrate compliance. You do need to, I think, conduct audits, and I think ideally external audits is a good practice, probably annually at a minimum, or when there is a significant change that at a minimum involves, spot checking employees across all categories in your business to ascertain, do we have the right industrial instrument identified for that worker? Have, based upon their duties, qualifications and experience, we properly classified that worker? Have we complied with any requirements in the instrument for actually setting up the engagement around notifications of their level, notifications of their status, and notifications of their working arrangements, where we make variations? And this is particularly significant, for example, for part-time employees, where a lot of the awards will say, if you agree on a particular initial roster, but then subsequently change it, any work outside that subsequently, any work outside the initial roster is actually overtime. Are we ensuring that we're getting proper agreements in place for those sorts of amendments? So you really do need to, at the very least, sort of spot check to identify those kinds of issues around level setting, minimum pay, and then applying, any paying conditions that arise because of the specific roster applied by the worker, and then test that against your records to make sure it's right.
Fantastic. Thank you. So just conscious of time, we are at our Q&A session. We have had a couple of questions come up in the chat. So I'll just reiterate for the person who asks about the right to disconnect policy, that is available in Xemplo. So if you go into your company settings in the library where documents are configured, you'll find the links to all of our policy documents, including right to disconnect, as well as there's about 12, 15 policies in there now, slowly growing that library. There's a new one to be released shortly for expense management. We recently released one about hybrid working and a safety and wellbeing checklist that goes with that hybrid working policy recently. So I'll share some information about how you can access those after the session as well. First question that we have for our Q&A session, though, was about PAYG contractors. What are they categorised as? Are they casuals? And does that mean they have leave entitlements? And assuming there's an assumption there that they wouldn't be ABN contractors, but I think, Steve, they're looking for some clarification from you.
No troubles, Ray, and thank you for submitting the question to the attendee. Casuals, part-time employees, permanent employees, maximum term employees, fixed-term contractors, fixed-term employees, ABN contractors, sole traders. There's a million different names we give to people who are doing work for us in a business, and particularly in a contingent worker setting. Despite all of the labels, there's really only two categories, that are really critical to get right at the start. That is, are you an employee or are you a contractor? You can only be one or the other. And I think if someone is not in business for themselves and doesn't have an ABN, then they cannot be a contractor. They will be your employee. And so now you know they are your employee, the decision needs to be made, what type of employee are they? Are they a casual employee, or are they some other type of employee, whether that be part-time or full-time? There's a very good chance that someone who's a PAYG contractor is a casual employee. They'll definitely be a casual employee if there's no firm advance commitment around how they're working and you're just offering them shifts here and there. What are the consequences of that? Do they get leave? The short answer is no. If they are a genuine casual employee, they don't get leave. But what they do receive, and what's important for your contracts to identify, is that there is a casual loading paid to them, and it's usually 25%. It's certainly 25% under the Fair Work Act's minimum wage instruments and awards, and that 25% compensates casual employees for missing out on the entitlements of full-time employment, like annual leave, sick leave, notice of termination, redundancy pay, and protections from unfair dismissal and the like. Now, what I would say, just in addition to all of that, is say, yes, very good chance they're a casual employee, but be aware an employee can be misclassified as a casual employee too. So just as you can misclassify a worker as an independent contractor when they are indeed an employee, you can misclassify an employee as a casual when they are indeed an ongoing employee. So what I would suggest, you do with casual employees who have been with you for a long time, or casual employees who have developed what are, fairly regular patterns of hours, is to have a look at that workforce. Certainly reach out for advice if you need any, and make a call as to whether or not there's risk that they could in fact be deemed ongoing employees, and then therefore devise strategies for how to address the prospect that they are an ongoing employee.
So as a follow-up to that question, we have had another question through the Q&A. If they have set start and end assignment dates and a daily rate of pay, do they need to be classified as a contractor under an ABN?
No, they don't. It's certainly a common way to engage contingent workers, on an assignment where there is a start and end date, and to pay a daily rate. That in and of itself, those features, it may lend some support to a conclusion that an individual is a contractor, but it's certainly not definitive. You need to go through the same, tests that I mentioned earlier that are back in vogue, which are, the multi-factor tests that look at the totality of the arrangement to help make a call as to whether or not the worker falls on one side or the other of the binary divide between independent contractor and employee. As I said, I think there is much more risk associated now with simply treating anyone who comes to you with an ABN as an independent contractor purely because they've got an ABN. You need to do more. You need to look behind the ABN, do a proper assessment, and make a decision around whether they're actually your employee rather than in business for themselves. And that's something we can certainly help with. We've certainly got tools that will allow those assessments to be conducted more easily for businesses, and where, the better view is that they are employees. You then need to ensure that you're complying with things like your pay-as-you-go obligations, superannuation obligations, but also the awards and the Fair Work Act.
So actually on the subject of the previous question as well, as thank you, Steve, for that answer first, I should say.
Okay.
If you were looking for some guidance in terms of what a casual loading contract statement could look like, again, same as a right to disconnect, you can actually load up, whether you use it or not. Using the Xemplo contract builder, you can actually load up an example of a contract and a casual contract. You'll have to pick one of those from the library. That will include an example of a casual, a loading clause that explains that there is a loading applied that covers all of a range of different obligations. So if you don't have one of those in your own contract and you're looking to add one, that's potentially how you could find one. However, even the name multi-factor testing to assess what kind of engagement, it really sounds like something that you need to engage in an expert for. I don't know about all of you, but that's what I would be doing. So is that something that employment law offers, Steve?
Absolutely.
Or you can give,
yeah,
push people
absolutely.
in the right direction.
And look, what I'd say in the context of contingent work in particular, where there is uncertainty, between you and the client as to how often a client is going to engage, you to supply a particular worker, it's perfectly acceptable, I think, at least for the initial engagement, for that to be on a casual basis. But you just need to be aware if over time that develops into something that is more permanent, that the worker will have the ability to raise through casual conversion processes, a request to become a permanent employee. And if they do, then encourage you to reach out. But there are some pretty strict processes that apply for you to assess whether or not they are required to be converted into an ongoing employee.
Awesome. Thank you, Steve. And thank you, Steve, for all of your fantastic insights. Thank you, Darren, as well, for sharing everything that you've that you've learned through your Platinum WFM journey and here at Xemplo as well. It's been fantastic to leverage your knowledge and understanding of the space in today's session. If you have any questions after today's session, please reach out to us. We would be happy to point you in the right direction or help you to understand what you have available already if you were a Xemplo user already. Thank you to everybody who asked questions via the Q&A. If we didn't get to all of them, we will follow up with you after the session. But thank you so much to everybody who attended today's session. This will be the first of a few webinar sessions we have coming up over the next 6 months about various subject matters of interest, including, I think on the radar shortly, we have one about background checking, as well as our training catalogue and some about the new performance features that are being added to Xemplo next year. Steve's going to talk about performance and how it relates to contingent workforces in an upcoming webinar in March as well. So hope to see all of you there. Thank you so much for joining us today. And everyone have a great day. Thanks again, Darren and Steve.